Please be seated. Okay, welcome. As you know, we're here on U.S. versus Modern. Each side, you all have 14 minutes. You may keep counsel however much time you wish for rebuttal, but you have to keep your time yourself. And please proceed.
Thank you, Your Honor. Good afternoon, Chief Judge Timmer, Associate Judges. May it please the Court. My name is Sharon Hayashida, and I represent the appellant, Emily Modern. At this time, I would like to reserve 1 minute for rebuttal. Thank you, Your Honor. Your Honors, protecting the public cannot justify the infringement upon an individual's fundamental Fifth Amendment rights. Thus, this court should deny the lower court's ruling for the following 2 reasons. First, Ms. Modern was in custody, as any reasonable person under such circumstances would not have felt free to leave. Second, Ms. Modern's statements were obtained through violating her rights. To the first point on the issue of custody, the law demonstrates that custody exists when an officer establishes a setting in which a reasonable person would not be able to freely terminate the interrogation and leave.
Counsel, may I ask you about that? From what standard should we assess a reasonable person? Is this any reasonable person in our society, or a reasonable person with Ms. Modern's background? She was graduated from law school. She has a PhD. She's a well-educated person. Do we assess that reasonable person with that type of a background?
No, Your Honor. We would assess any reasonable person in this society under such circumstances, so under Ms. Modern's situations at this time. So the court would take an objective approach, not taking into any subjective beliefs or backgrounds here.
So we're supposed to assume someone with what level of education or understanding of their rights?
Again, a reasonable person just in the society who is able to communicate, read, understand, right, but doesn't necessarily need to have the background that Ms. Modern had.
Are you asserting that there are any clear errors of factual findings? Are you alleging that any of the factual findings of the district court were clearly erroneous?
No, Your Honor. However, what I will be arguing today is how the perspective is a little different here. When we're reading things as is, it can be taken in a complete different light. For instance, we see in here, in the court records, we see that Ms. Modern was instructed to go into read with a certain type of language. Now, as opposing counsel may argue, that specific sentence that the officer had used was friendly and is inviting. What we'll see here today is that even that tone and demeanor that accompanied that very request was very intimidating and also created this authoritative atmosphere.
Counsel, at what point are you telling this court that the custody began?
The custody, yes, thank you, Your Honor. This custody began the moment that the officer had now instructed Ms. Modern to go into the very read here, as we see in 2021 in 7th Circuit Court. Although it's not binding, United States versus Leal, they did not find custody when the defendant voluntarily consented to every stage of the interrogation, such as stepping out of the car, complying to a pat-down, surrendering wallets, keys, answering the questions of these officers. However, in this case, starting from the get-go, we see that Ms. Modern did not show this voluntary consent when she was asked to go in. As we see on record on page 32, we see that she was even asked twice, and she didn't want to initially go in. So that's when we can argue that custody first began there.
Well, it's her store, right?
Yes.
It's her store. Both businesses were her businesses. What would lead, I guess, a reasonable person to conclude that they had to go? Like, why did she have to go with them?
Yes, Your Honor, thank you so much. And that compares actually to even 2002, where this court in United States versus Kim also found custody when, even though the defendant was questioned in her own store. We see that again, when someone is questioned in a familiar surrounding, that tends to weigh against finding custody. However, the familiarity of a location is neutralized when the defendant is isolated from the outside world, and furthermore, when that person is interrogated in a police-dominated atmosphere.
Well, didn't we say in U.S. versus Brops that, I mean, there's no show of force, and the uniforms, et cetera, are negated by the familiarity that your client had with the police officers. So why do we come to a different conclusion here?
Yes. Well, to answer that question, Your Honor, in 2007, the First Circuit Court in United States versus Mattel-Carey found that the factor that carried the most weight in determining custody was the level of control that these officers exercise over the defendant. So even in this case, although she was, again, questioned in a familiar location, in her store, we can find that she was in custody given that the officers here also exercise a similar level of physical control over her here.
But that was the First Circuit, and we've got cases in the Ninth Circuit which seem to go a little bit differently. So why should we abandon that and follow the First Circuit or the Seventh Circuit with the Leal case?
Yes, Your Honor. Not necessarily to abandon it. Again, it's not binding. However, it's definitely a persuasive precedent that the court can look to get a better understanding how custody can exist when an officer establishes a setting in which a reasonable person under such circumstances would not be able to freely leave in this case. And we can see that this is also exacerbated when when Ms. Modern was questioned in Reed and she tried to get up to go grab a glass of water during the interrogation. However, the officer there immediately demanded her to sit down while the officer went to go get the water. So we could see even here, Ms. Modern was not freely able to get up, terminate the interrogation, and leave the very room.
Doesn't that cut both ways, though? I mean, I could see certainly, it depends how it's said. If you say sit down, all right, you feel like you need to sit down. But it could be sit down, I'll get it for you. So how are we to know on here? Don't we have to kind of get back to Judge McKenna's question here? Don't we have to simply trust the trial court to assess that, to make that assessment and make that ruling?
That's correct, Your Honor. However, as we see on evidence on page 31 and 32, Ms. Modern also testified that tone was far more serious here, which was definitely a lot different from the tone that the officers would typically use in their usual small talks, small banter here as well. So we can see that very tone that also came in accompanied with that very request came off in a very authoritative, instructive way, which again would find in favor of custody.
Well, you know, the district court doesn't really talk about tone, et cetera, and its findings. And I'm wondering, what relief are you actually requesting? Are you asking this court to rule that the questioning did violate your client's Fifth Amendment rights, or are you asking for a remand for further fact-finding? Yes,
Your Honor. This appellant here is asking for a remand here, as again, Ms. Modern's rights were violated here when the officers did not inform her rightfully of a Miranda warnings.
You're saying that we should just vacate and remand for additional fact-finding, or are you asking us to find that your client's Fifth Amendment rights were violated? I'm a little confused.
I apologize for the confusion, Your Honor. Specifically, remanding in terms of also finding further facts here, because it seems like the lower court didn't take into consideration of every single thing that had occurred here. So,
well, where does that come from? I mean, the court had the benefit of the record, the motions, the briefs of the parties. What other facts are to be gleaned?
That's correct. So, Your Honor, in this case, I do think that the court would benefit in understanding a little bit more of the comprehensive timeline that also took place. Also, even getting the testimony from even the coworker at that time, again, because custody exists when any reasonable person under such circumstances would not feel free to leave. that very thing. So the court would benefit also receiving a testimony from the very coworker that was present at that scene.
Are you alleging any errors of law by the district court here?
No, Your Honor, I am not at this time. However, we are arguing that this court should see and look to other cases as well to take into consideration how custody can exist when there are tones. The physical surroundings are also neutralized. Also, the degree of pressure applied here.
But counsel, early in this interaction between the officer and the defendant, much of the conversation was conversation about her aunt. So in what way was she confronted about guilt? And at what point in the interrogation did that happen? And should we be looking at that time frame?
Yes, Your Honor. So it is true that she was asked questions directly about her aunt. However, those questions were directly related to the crime that she has been charged, which is the knowledge of possessing a stolen item here. And those questions that the officer had asked were meticulously crafted to elicit self-incriminating statements that would gauge her level of knowledge of how her aunt possessed that very stolen book.
But the officer didn't even know at the time that she had the particular book.
Well, Your Honor.
When was that confirmed?
Oh, yes. Sorry about that. Your Honor, yes, it was confirmed after around 7:50 when the officer had stepped down, confirmed with the officer who was waiting for breakfast in the other coffee shop. However, before this interrogation had happened, Officer Keel did testify in her testimony that she was reminded of that brief that had happened earlier in the week. So she was well aware that crime had committed in the Getty Museum.
Let me ask you a question. If the whole interaction had taken place at the counter, so they never went in the other room, would you still be telling this court that should be excluded and was a violation of her Fifth Amendment rights?
Yes, Your Honor, because again, it's not just a physical location that this court should take into consideration, because again, it's the totality of all circumstances. So given even the tone, the language that was used here, even the duration of this very interrogation should all be taken into factors and therefore should weigh in finding of custody.
So you're saying which of the five Kim factors are you saying cut in your client's favor?
To answer that very question, it would be determining the custody of the level of physical control, which again encompasses even the language, even the very place that she was questioned and the duration that was there, also the degree of pressure that was applied to Ms. Madern at this time.
So you're saying all five factors cut in your client's favor?
That's correct, Your Honor.
How do you distinguish this from the U.S. versus Bagsanani case? I mean, there you had 4 officers who serve a search warrant, get the gentleman to escort him to a conference room where 2 officers are inside. They get his car keys, even to go search his car, and yet in that scenario, the court said that's still not enough to find someone in custody. Isn't that, I mean, gee, if you can't have custody there, how can we find it here?
Yes, Your Honor. Again, in there too, the court did take into consideration other factors as well, such as the type of tone that the officer conducted the interrogation, and as a result of that, the court did find that there was no custody. However, here, Ms. Madern, was in an interrogation where this tone was conducted in a mocking, accusatorial way. So to the second point, again, because Ms. Madern was in custody, she should have been rightfully informed of her Miranda warnings. And in 1966, the Supreme Court in Miranda versus Arizona established a requirement for officers to inform suspects of their Miranda warnings when they're subject to an interrogation while in custody. And as we see here, Miranda rights are important because they're safeguards to protect an individual's precious Fifth Amendment rights. So here, although the court did say statements that are voluntarily given are not barred by the Fifth Amendment right, we see here, on the contrary, Ms. Madern's statements were not given in a voluntary light as the officers used coercive tactics to compel her to speaking self-incriminating statements. So as a result, in conclusion, this court should deny the lower court's ruling because one's right should never be violated, especially in a situation. Your Honor, I see that my time had expired. May I briefly conclude?
Yes.
Thank you so much, Your Honor. So again, because one's right should never be violated, especially in a situation where no reasonable person would feel free to leave. Thank you so much.
Thank you. And just to be clear, is 1 more minute left for rebuttal, or was that it? Okay, great. Counsel, please.
Good afternoon, Chief Judge Timmer. Good afternoon, Associate Judges. May it please the Court. My name is Ali Amini, and today I'll be representing the respondent in this matter, the United States of America. What we have here is nothing more than a good old-fashioned confession. This Court should affirm the lower court's ruling, denying the defendant's motion to suppress her statements for the following reasons. First, Modern voluntarily agreed to speak with Officer Keel. Nobody forced her to go in to read. Second, the interrogation did not take place in a police-dominated atmosphere. It took place in a very familiar location. And third, Modern was never handcuffed nor told she was under arrest during the interrogation. The United States Supreme Court, in 1966 case, Miranda v. Arizona, has told us that the Fifth Amendment privilege serves to protect individuals from being compelled to incriminate themselves. However, police are permitted to engage in general questioning of citizens in the fact-finding process. We must maintain law and order, and the Fifth Amendment was not designed to protect law enforcement from doing the...
In terms of general questioning, it talks about general questioning. It's not this prolonged 30 to 50, 55-minute questioning, right? I mean, how can we say that this is general questioning? This was targeted questioning regarding a specific book that this officer knew had been stolen.
Yes, Your Honor, it may have been. However, it was the defendant herself who brought up the book in the first place. It was a general, casual conversation about a book. She brought up that they own the bookstore, that her family owns the bookstore next door. And as Miranda also says, the Supreme Court established that their decision in Miranda did not in any way preclude police from carrying out their traditional investigatory functions. This was a stroke of luck for law enforcement. There was a case that they had to solve, and they happened to come up on some information that could have led to solve it. Miranda wasn't meant to stop against simple inquiries to catch criminals.
Counsel, at some point, didn't this casual conversation turn into something more? You have 4 uniformed officers who are armed, who come into the business, who direct her to go into an area that is closed, that has no exit. One of them tells her where to sit, 2 block the door. And at that point, isn't there something different about the casual conversation? No? Yes?
Possibly, Your Honor. However, as to my first point, the defendant voluntarily engaged in this. As opposing counsel mentions, opposing counsel states that when Keel asked Modern to step away, her tone got very serious. The whole entire mood switched. However, the record on page 35, when they're asking Modern at the evidentiary hearing, when you followed Keel, did she say you had to go with her? Modern says no. Did she threaten you if you didn't go with her? She says no. Did she insist for you to go with her in an aggressive or threatening manner? Modern says no. All of these facts show that Modern voluntarily agreed to accompany Keel into the other room.
You know, I mean, as a practical matter, most of us, I think, if an armed, uniformed police officer asks us to do something, we're all rule followers, and we're going to go do that. So the idea, I mean, do you have to have that kind of threatening, coercive language in order for someone to feel like they really have no choice but to go and do as they're asked?
Not necessarily, Your Honor. However, this case differs from the other cases, such as the case of United States v. Probst that this court decided in 2009, and in virtually all the other precedent cases before us today. Modern was familiar with the officers. An armed officer that you know that you've met a dozen times to come buy coffee from you and have a casual chat, even raising eyebrows, is not going to have the same implication as 3 or 4 officers showing up at your house as they did at Probst being armed. In that situation, the fact that the officers are armed is definitely a lot more serious than in the instant case.
But look at the facts of this case. They take her into a separate adjoining room, sit her down on a table with her back toward her store, with 2 armed police officers blocking the entrance back into her store. How is that not coercive?
Your Honor, this is much more similar to the case with Bassignani. The cases of the physical surroundings being led into another room is almost identical to Bassignani. However, in Bassignani, there was a door. It was closed. In this instance, sure, it was another room. She voluntarily went in there. They sat her down. However, there's nothing to show that she wasn't free to leave whenever she wanted. And the court in Bassignani found that the physical surroundings, although he was sitting across the table from another detective, just as Modern was, there was 2 or 3 other officers in the room, people going in and out. This court established in Bassignani that the physical surroundings were not police-dominated and not indicative of custody.
Counsel, didn't she try to leave? She tried to go get water, and she was told to sit down.
Yes,
so
Counsel.
At that point, is that a different point in this colloquy?
No, Your Honor, because during the time when she stood up to go get the water, the record states that she was hysterical and she was crying. And as Chief Justice Timmer mentioned, when she told her to sit down, Officer Keel, it wasn't so much of a yelling or a demand. They were friendly acquaintances, as mentioned in the record. She wanted to get her some water and have her sit down. And also, not to mention, Keel was at work. Forgive me, Modern was at work. Should she be hysterical and crying, leaving back to what? To go make coffees while she's crying? And
so the officer told her to sit down for her benefit.
She told her to, yes, and she brought her water for her benefit, Your Honor.
Is that in the findings? I don't see that in the findings. Aren't you adding to the findings something that's not there?
No, Your Honor, I apologize. It doesn't explicitly say it was to her benefit, but she wanted to help her out. She brought her the water.
How can you speak about the intent of the officers? I do not see that in the findings.
She wanted to make sure that she was comfortable, and in the record, it does state that she was waiting and...
Whatever the record says, because Ms. Modern has a different take on the situation. We're talking about the district court's findings here. Are you alleging that they are clearly erroneous? Some portion of the findings are clearly erroneous?
No, Your Honor, I'm not.
Then is it proper for you to be interjecting additional findings into the findings that are not within the district court's findings? Now, opposing counsel is suggesting that the conviction be set aside, the matter be remanded for additional findings on what appears to be additional Kim factors. What is the government's position with respect to that?
The government's position is that the district court got it right the first time. Modern was not in custody during the interrogation for the aforementioned reasons that I've mentioned. And more about the police-dominated atmosphere, to my second point. This court in 2002 in the United States v. Kim, they also mentioned that locked doors and closed doors, as I mentioned earlier in Bassignani, however, not just closed, locked doors show that an individual is in a police-dominated atmosphere. Although the 2 police officers were standing in the hallway observing, there was no physical door or barrier to prevent Modern from leaving. And also later in the interview, not only the water incident, Modern did stand up. She went on her own accord. The officers did not tell her to go receive the book when she received it. She stood up on her own accord and went out of the vision for 1 or 2 minutes of the officers. And the ultimate inquiry, in United States v. Props, this court in 2009, is that an individual is in custody when the situation is such that it's similar to a formal arrest. And in a formal arrest, when one is in custody, police officers would never allow an individual out of their sight. That clearly shows that the situation was not police-dominated. She left the scene for a minute or 2.
You mentioned our U.S. versus Kim case, and that's where we outline the paradigm of factors to look at and to weigh in looking at the totality of the circumstances. Could you tell us, one, whether, how we're supposed to weigh that? Are they all given equal weight, or can some be given more weight, or only some exist and that'll carry the day? And also, do we look to other factors outside those? Is it an exclusive list or a non-exclusive list?
It is not an exclusive list, Your Honor. We look at each individual factor, and it is up to the honorable panel before me and decide how much weight we accord to each factor. But also more important, as opposing counsel states, it is the totality of the circumstance. In some instances, we can have 2 factors decided custody, and yet when the court takes a step back and observes the individual situation, such as here, where in the United States Court of Appeals case for the Seventh Circuit, in United States v. Leal in 2021, although not binding, the court reasons that we use the objective test because it avoids burdening police from having to analyze every single individual's mind before asking questions and Mirandizing. And what we have here is Modern's guilty conscience. As the
So do you agree in response to Judge Stiglitz's question to opposing counsel indicated that we look at it as a reasonable person under any circumstance. So it's just a generic human being, and you do not factor in that this Ms. Modern was someone with a JD and a PhD. Do you agree with that response?
Yes, Your Honor, we do look at it as from a reasonable person standard.
So when this court in Kim discussed the fact that the defendant there had limited English proficiency, were we not looking at the person as a person rather than a generic English speaker? So it's a little, so the government is conceding that it should just be a reasonable person, and it doesn't matter whether that person has perhaps limited cognition or limited English speaking ability. Those are not factors that we are to consider whether a reasonable person in that situation would find it difficult to leave or cause the officers to leave?
Your Honor, it is quite a bit different between the Kim case and the instant case, because although the court, it should be a reasonable standard, and we shouldn't take in the fact that Modern is a PhD student. However, with Kim, language is quite a bit different, because no matter how educated one is, if you don't speak the language that the officers are talking to you in, it would be rather difficult to comply or get an understanding of the situation. And Modern, she voluntarily, like I said, accompanied, and forgive me, in the Kim case, the courts also state that in determining whether suspects are in custody for Miranda purposes, the Supreme Court has considered not only whether they voluntarily accompany officers, which Modern did, it's whether they voluntarily accompany officers understanding that questioning would ensue. And perhaps this is where the language factor comes in Kim, although this court decided in Kim that the language to summon was not telling as to custody. In this case, it's clear as day that Modern knew that Kiel wanted to ask more questions, and that's why she went into the other room. So we can say that she voluntarily consented to the questioning.
Counsel, defendant's counsel alleges that all of the Kim factors weigh in favor of her client. Are there any factors of the Kim factors that you believe weigh most heavily for the government?
Absolutely, Your Honor. I would argue the evidence of guilt factor. On the record on page 36, Modern states herself that Officer Kiel never told her that she was suspected of receiving stolen property. And even in the beginning, when Officer Kiel asked Modern to step away and speak, at that point, Officer Kiel didn't know that her aunt had worked at the Getty. She only found that out after. All she knew was the book. She just simply, as Miranda states, she was carrying out her traditional investigatory functions as a police officer. And if Miranda was designed to prevent the simple interrogation such as this, then we're essentially handcuffing our police officers and not allowing them to do their job. The situation in this case and in Kim is drastically different. In Kim, there was absolute police domination over the store. They locked her inside, separated her from her husband, separated her from her son, told her to shut up.
I'm sorry.
It seems like that we're talking about the strongest factors for the defense and strongest for the government. To me, at least, one of the weaker factors for the government is the time. As you say, is casual conversation about what's going on, what you know about a book. She's working at. I know it wasn't crowded at the time, but it's the morning in a coffee place, and take her away for 50 minutes. It seems like at some point that maybe migrates into now it's suggests custody. That's a long time to keep someone away from their work, especially when you could have just had that conversation because no one else was there at the time it started. So could you assuage my concerns there?
Yes, Your Honor. I do believe that is essentially speculation. We just don't know. Had a morning rush came in, unfortunately it didn't happen. We don't know if Kiel if she would have been allowed to go back inside into Brew and make coffee. But it seems that she would be, as she was allowed to go, get up, and get
But
the book.
didn't she see a customer, and she didn't get up to go help that customer, correct?
She did not, however, this is why I stated to Chief Judge Timmer's question, if the morning rush came in. There was one other employee working behind the counter. One customer, it wasn't necessary for her to get up and go continue making the coffees for them.
Along the lines of what the Chief Judge and Judge Stiglitz have already asked, in Brasignani, at the very beginning, the officers said, you are not under arrest. You are not under arrest. You're going to be free to leave when we're finished. But in this case, at what point was Ms. Modern told she was not under arrest?
I see my time is over. May I briefly answer the question?
You may.
Modern was told that she was not under arrest towards the end of the interrogation. And what we have in this case is nothing more than Modern's guilty conscience taking over and spilling the truth. For the foregoing reasons, I ask that this court affirm the trial court's decision denying the defendant's motion to suppress her statements because she was in custody. Thank you.
Thank you. Ms. Hirochito, please.
Thank you, Your Honors. Your Honor, no one's right should be violated, especially if they're in custody. My opposing counsel did explain how, there might have been a morning rush, therefore, that conversation couldn't happen in the very coffee shop. However, there are no facts indicating that on record, therefore, that it could be very speculative here. In addition to that, also opposing counsel did explain that, there was a brief moment where the Ms. Modern was able to get up and just freely move, but however, she was only remaining in that very room that she was isolated within. And also, opposing counsel did say that their court was identical to Bassignani. However, I beg to differ on here, as here, 2 officers were in the conference room. However, they did shortly exit the room as soon as the interrogation started. So as a result of that here, too, these 2 fully armed officers, Your Honor, I see that my time has expired. May I briefly conclude here?
You briefly conclude.
Thank you so much. So seeing that they stated the duration of this very interrogation, for these following reasons, this court should deny the lower court's ruling. Thank you so much.
Thank you. Thank both counsel for their argument and their briefing in this case. We'll take the matter under advisement and issue a ruling. Probably never, but but we'll recess in order to go back and talk about the case.
If you'd all briefly join me in applause for
I think I'll put this way.
All right, be seated. Thank you.
Good job. Good job.
How do you guys feel?
Can you believe it? You are first-year students, and you are arguing in front of Supreme Court justices, 3 Supreme Court justices. It's absolutely incredible. I can't believe it. You sounded like lawyers. Just an incredible job, right? Definitely. I think Alicia's going, oh my God. Alicia did. Oh, she did, I know. But sometimes when you lose in the semifinal round, you go, oh my God, thank God I wasn't. It's done. Yeah. Everyone relax.
Of course, maybe you got some questions you didn't expect. But it was really a joy to watch you work with it. It was fun, and you handled it well. You both handled it well.
That's the playtime of it. That's when they know they can play with you, when they start asking questions.
Like right now, I start.
I feel like that's how it is. Like, but I think it's because when you're a baby, it's like you're in your element, and it's like, and it's such a fantastic.
I think usually I don't say that. I'm myself, but actually I proud myself.
Yeah, that's what we hope. We hope you guys feel good about it.
Why
Feel
this?
proud. Because, like, it's such an incredible.
I don't know if I can teach that. I was so proud, you guys.
Has anyone figured out how to pronounce the Basignani, Basignani? It is, you pronounce it, like if it's Italian, then you wouldn't know.
It's like a meal. Like
It is Italian? I mean, a little late for us.
Technically it's leal too, but I would just say
Yeah.
leal. Because I wasn't sure what to say like themselves were saying leal, so I'm not sure to say leal. But I saw them full
No, it was I noticed that it was slower.
Yeah. As they mentioned earlier,
Proud.
two future justices, they quarters of them,
Yeah, I mean, you would.
saying that.
What are we asking? Are we asking?
Yeah, it's not something that you would have dug into deeply, but I think like you kind of just take those things.
She was saying the same thing.
That's
It was so wonderful. She loved it.
I think
Your invitation's
yeah.
in the mail.
I mean, that's something that we all work on. It's like what's the standard
I said, I got it before you started.
Or
Yes, it was so funny.
what should the following procedure
We just want to come on here. They were delighted.
Okay, yeah, but.
What was the standard? Were you guys summary judgment?
It was, yes, it was some, for us, we had a motion, for summary judgment,
Yeah, you guys kind of had a rough time because we all had summary judgment motions, and so your motion is like more complicated.
Oh, yes.
so the procedure
Yeah.
was really about whether or not there were tribal issues of
Material.
fact.
Yeah.
And so that was something like we would get into a lot for tribal issues, but you guys did so well. We're so impressed. We're so impressed, and I hope you guys feel proud, feel good about
Yeah, I'm glad it's done.
Was it the Brittany?
Yeah, it was a high school football.
Yeah.
Just talking to the judges, justice was casual. Yeah, one of them was a justice for Supreme Court. Yeah, justice for Hawaii.
It was actually, for us, it was a great process because it started the, all policy, right? People who graduate 10, 15, 20 years ago connected their law problems. Yes, because I was hearing in their mind. I do. Mine was strict liability on a dog bite. Yeah.
Oh.
But it also included, you weren't negligent spoliation. No. That was, but your year there were 2 issues, weren't there? Yes, yes. There's always, that's when we still did teams, right? Oh, well, yes. I'm trying to remember, I think Patty and I were on the same team. It was interesting because we stopped teams because.
Oh, the camera?
Imagine.
Yeah. So
Oh, yeah, no, this is not for,
I said, yeah. They write the brief together, bad. Stop that.
Oh,
So there's no, that camera's not working on here? That's on him?
This team works.
Yeah, camera's on him.
These teams work.
Yes.
I thought I brought this in.
Yes.
You might have said it.
What was your problem?
Interesting, thanks
We
for
didn't
letting
have
us know.
report. We started
for
with court the year,
legal
we
writing?
started with court the year I
That
was on
camera?
bar review, so I was a judge. Yeah, so, there was.
All right.
We had no court, but no.
Ah.
Please be seated. Okay, well, you all did both an excellent job. And I think you're supposed to make your remarks first.
If I may briefly.
Yes.
Thank you.
I've already disregarded his instructions, sorry.
So I hope you all saw how lucky we are to have this bench before us today. Supreme Court justices who are here to engage with these talented students on this problem. I want to highlight that they do this year after year. They're dedicated to this school and to this program. And so on behalf of the program and the Board of Governors, we just want to say thank you. I mean, you've given so much year after year, especially traveling to join us today. So we wanted to give a little back. So what we've done this year is we've made a donation to the St. Jude's Children's Hospital in each of your names as a token of our gratitude in this, perhaps something a little bit different and towards a good cause. So I have just a note for each of you, and just want to say on behalf of the program, we're so grateful that you're here.
Thank you. Thank you.
Thank you.
Thank you. That's
Lovely.
wonderful.
That's an excellent
Yeah.
idea, and
That's a
I'm
great
I
idea.
think all of us, when we do things like this, we don't do it with the expectation, you get a little medallion or whatever. But although we like stuff, that's true. This is terrific, though, and I don't think in my 24 years as a judge anybody's ever made a donation on my behalf. So thank you very much.
Yeah.
I think the way this is going to go, am I right, Ryan, that we introduce ourselves and then we give some feedback and then we announce the winner. Is that what you want?
Yes. Yeah.
He's thinking. That's what you like. Okay. Well, my name is Ann Timmer, and I am currently serve as the Vice Chief Justice of the Arizona Supreme Court. Sits in Phoenix, and I've been on the court for 12 years.
She will be Chief Justice as of July 1st.
In a little bit. Thank you. And by the way, I probably confused you because I said I was a judge for 24 years, but I've been on that court for 12, but I was on the Intermediate Court of Appeals for 12 years as well. Going next?
Okay. My name's Lydia Stiglich. I'm the Associate Chief Justice of the Nevada Supreme Court. I just finished my stint as chief, so good luck to you on that. And thank you for having me. And this is really the kindest, most thoughtful gift I've ever gotten. Thank you.
Hi, I'm Sabrina McKenna, and I have been on the Hawaii Supreme Court since 2011. I was a trial judge from late 1993 until I joined this court in 2011. So I have been on the bench for over 30 years. And just before I joined the bench, I was an assistant professor at the University of Hawaii William S. Richardson School of Law. And before that, I was a practitioner. And thank you. This is such a wonderful idea. This is such a great idea. Thank you.
Great. Okay, so I think Sabrina had proposed that we just give Justice McKenna.
No, Sabrina.
We're back to Justice. Give a little bit of feedback and then announce the winner, right? So that I will take the prerogative and start first by giving both of you feedback. One, I would be delighted to have either of you in our court. I think you both have, as I always find with Southwestern, this is really an elevated standard that you have risen to. And so you both did a tremendous job. And just specifically, you both had, what you had in common, you had great, what you expect. You answered the questions. And that's, I think, the biggest flaw that I see litigants engage in is not listening to what the bench wants to talk about and actually answering the question. And I thought both of you did a terrific job of that, of answering the question, even when it got a little spirited for you. A couple of things, you stayed in there and you were professional and you answered the question, which I thought was terrific. And so I'm trying to think of any picky little points for either of you. I think, and I hope I'm pronouncing it right, is it Hirachita? Close as I can get. I thought that if I would give you any advice, I would get it clear of what you want us to do. It's funny how people will come in and they've got all their legal arguments and they're ready to go and whatever, and then somebody says, well, so what do you want? And it stymies people sometimes. So I would think that out in advance, because I don't think you really want us to send this back to have the judge do a redo. You want us to say, hey, she was in custody, get rid of all those statements, right? That's what you want. So they think that kind of thing through your relief. That's a common thing, oddly, that I find people do. They hadn't really thought through what they want if they win. And Mr. Amini, I think for you, I really, I thought you had you handled Justice McKenna well when she was saying you've gone a little too far. I was very impressed that you picked up on you were listening, obviously, because you picked up on what I said in the first argument and repeated it back, which I thought was terrific. But then you went a little far past the findings. But what can you do at that point? You can say, yep, you're right. And I thought that was a good way to handle it. But sticking to the record, and both of you did a great job of that, and kind of intimidating on page 31 of the record. In real life, you're never going to get that. But I thought it was, you both did a wonderful job, and you have bright careers ahead of you, so congratulations. You want to go next? Sabrina?
Both of you were excellent, seriously excellent. I'll just repeat, just agree with everything that Justice Timmer has already said. I would be so happy to have either of you in our courtroom. And you really knew the cases, you knew the law. This was actually a kind of a tough case, where I'll tell you that, it's a little bit unclear to me. I would probably rule that at some point it became custody, because I would distinguish because she wasn't told that she wasn't under arrest. But we go back, I'm not sure what the law is in the Ninth Circuit. Is it a completely objective standard human being? Or is it totality of the circumstances based on this person? Because if it's totality of the circumstances based on this person, she's a JD. She's a JD. I was like, a what? Right? So I think that it's different, because in Kim, they talked about the Ninth Circuit talked about the fact that she had some limited English. And they factored that in on the custody issue. They didn't really rely on, but they talk about that. So, yeah, I don't know what the Ninth Circuit law is. And let me just, we deal with custody issues, and I would probably have said that under our state constitution, at some point this became custodial interrogation. I'm a little bit unclear exactly when, but in any event, I thought both of you did really well responding to our questions. And I know I don't really have anything additional to say. You guys are going to go really far. I hope you stick to litigation, become litigators, all right? Okay.
So I thought it was just excellent, and either one of you could have been attorney, or better than many of the attorneys that appear in front of the Supreme Court, at least my Supreme Court. Maybe all the good ones are in Arizona.
No. Mixed bag.
I think a couple things is, don't forget, you're all well versed on the law. Don't forget the theater of the law and what's happening here, because there is some theater. So always being present, always being engaged, because in your mind you have a checklist. You're like, okay, I want to make sure I make these points. Okay, I need to mention those two cases. I need to, and so you're checklisting, and when you're checklisting, you're in here and you're not out here. And you have to always be present. Because, like, for instance, when you came out with the two cases, the Seventh Circuit, First Circuit, and I'm like, I don't care about them. We're the Ninth Circuit. And we were laughing in the back. In Nevada, we don't care what the Ninth Circuit does either, because they're not the boss of us.
Hawaii, too.
So always just not checking, not in your mind checking, but having that colloquy. I was trying to lay down, and I was hoping somebody would pick up the, at some point, I think there was an argument that it turned, because like anything, if you want it all your way, then you might lose. But maybe you're giving a middle ground, because maybe one of us wants to go farther than the other two. And so maybe when we get in the back and we get there like, I think it was garbage, and I'm like, well, but maybe to here. So you're always kind of leaving it as many options that would benefit your client or your client as you can for that. I thought you were all very responsive. Don't let judges suck you into something you're not meaning to do. So on the outside of the record, and I was like, she's getting spicy down there. But I'll say this, she kind of sucked you into that, and then it's like, well, that's not in the record. And you're like, oh, God, they were kind of asking me what I thought about that. So always where they usually get you is like hypos, for instance. With a hypo, you just take it. If it's not a fair hypo, you say, well, Your Honor, on these facts, I totally agree with you. I would lose on these facts. Those aren't the facts we have here, or that's not the fact in the record. But the best oral advocates, and all of you are well on your way to being excellent oral advocates, are the ones that are the most present, the ones that are the most conversational, that listen to what each other's saying, listen to what they're saying, and are responsive, because those are the most just really good advocates. And if you're not all going to win, because that's just the way it's set up, but the judges remember. Who's that? Who's an honest broker? Who's true to the record? Who concedes what they should, and who does that? So you both did an excellent job with that. I'm sure it's very nerve-wracking. We waited in the back a half hour at least just to make you stew in it, just a little bit and see how you handled it. But you all handled it with a lot of grace, and so thank you for giving us the privilege of sitting on this competition.
Okay, well, one of our jobs is we had to pick one of you, and that's the most difficult thing, because, of course, all three of us went back and said, well, how are we supposed to pick? You really were excellent, but we had to pick, so we have chosen Mr. Amini. Congratulations to both of you, and in the past, we have taken any kind of questions, and I think that we're, yes? Of course. Delighted to take any, not to say you have to, because I know we're behind time a little bit because we wanted to chill you the first half hour. So if you have any questions or anybody out there at all, we're delighted to answer them. So do you have any questions?
Shocked right now.
Probably not. They want to get to the banquet at 5 o'clock.
I know. Well, I'm cognizant of the time, so I'm not forcing you to ask questions, just offering it.
But this is your chance. You have we're a captive audience.
Yes, we are.
Do you have anything from the audience, from the participants?
I'm not sure if this is respectful, but could we get a picture with you?
Yeah.
Of course.
We figured that.
And we're all going to the banquet tonight, too, so frankly, you can ask the questions.
Can I throw one thing out, like now you all have appeared in front of us, and you should always be shameless makers of relationships. So in the future, you should send an email. I'm blah, blah. I met you at this thing. Like, that's how you start building relationships. I'm going to be there. Your Honor, would you have 5 minutes? Because I'm going to actually be at your court, and I'd love to come see you or do those things. Like, do those reach outs. I'm always open to those. I've hired law clerks because some randomly, attorney, they were good. But some guy in a 1L asked me to coffee. I'm like, who's this kid wants to have? Okay, I'll have coffee. And then 3 years later, I got the clerkship application. And I was like, really good, great. I remember him, and I remember that. Like, this whole career is relationships. So don't be shy about making them. Don't be shy about making them with each other, because you should be able to pick up the phone 10 years from now, 15 years from now, even people you weren't friends with, and say, hey, I'm from Southwestern, and I have, I X, Y, Z, whatever it is, but do that. That's the value of this, and that's the value of us. So reach out. And be well. For sure.
And I think I just want to finally just recognize Professor Carpenter and thank her for all of these years, right? time. Let's go.
Thank you, everyone, on behalf of the board, and thank you, Professor Carpenter, Professor Talia couldn't be here. Thank you to our panel of judges. Congratulations to our competitors. Thank you to all our guests. Thank you to program members and board. Have a great rest of your day.
Thank you, Ryan.
Let's see. Where shall we do it? Maybe like right over here? Yeah, stand right over here.
Thank you so much. Thank you so much. Wonderful. Thank you so much.
Maybe the three of us with the two finalists first? And then maybe you are just the organizer. I'm just really bossy. I'm sorry. Could you use my camera too? Thank you. We need somebody to organize. Yeah. Come on. Come in between. Oh, okay. Come in between. Okay. Actually, no.
There we go.